I have something in my hands that I'm going to. The lawyers like to say, I have in my hands something, something. So, Kaka, what do I have in my hands? Which one is this one? What's it
You
called?
have the warrant for the removal of the CJ,
So
I
this is the
believe.
warrant for the removal of the CJ. It reads thus: Republic of Ghana, now therefore know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the said Chief Justice Justice Gertrude Araba Esaba Saki Torkornoo from the office of Chief Justice and Justice of the Supreme Court with effect from the date hereof. In witness whereof I have hereunto set my set my hand and caused the presidential seal to be affixed at Accra 1st of September 2025. Okay, so what I'm going to do is we've been talking to a wide range of persons having reactions following this development. And so Professor Kojo Appiah Echia is a professor of law at the University of Ghana School of Law, and he's been speaking to us on this particular outcome. So let's bring you excerpts of that conversation. Later on Point of View, we had some guests. We'll bring you some of their perspective and we'll continue the conversation from there.
I would say that the constitutional process was duly followed from the time the petition was received, consultation with the Council of State, the setting up of the committee, the decision made by the committee today, the announcement by the president. I think all followed constitutional due process, if I can say.
Okay. Now, but when it comes to the process, one of your colleagues, I mean, when I say colleagues in the legal profession, the former deputy AG Kwenka has said to me earlier that you can follow the constitution but follow it with mischief, and he believes that that's what has happened this time around. And so the constitution is simply being used to execute a political agenda. I know you are not a political person, at least that's not what we are speaking to you about legal issues. The two issues that are being put out there now, how would you deal with it if you were in charge? Would you say that the Chief Justice has been afforded all the room to defend herself, and to the extent that that has been afforded her, we cannot say there was vindictiveness as the NPP side is claiming?
Well, I think that there's one thing to have the constitution and then one thing to discuss if the constitutional provisions relating to the steps and procedures for the removal of the Chief Justice is correct or meets the minimum threshold, and therefore it's important. It's an important step guaranteed in the Constitution to ensure the independence of the judiciary. I think that is where, in my opinion, it falls short a little bit, and so in that respect, it's one thing to say that the constitutional due process was followed, but I think that because of the gaps in there, it makes room for it gives room for abuse, and so in that sense, I think that the fact that the Constitution says so doesn't necessarily make the Constitution right, and I think that is why some have argued for necessary revisions in the Constitution, and some of us made such positions before the Constitution Review Committee to be able to consider such changes to ensure that it doesn't violate the minimum threshold to guarantee the independence and the sanctity of the judiciary.
So you are of the school of thought that thinks that the CJ's removal should be made as stringent as the removal of the president?
Probably so, but at least it has to go to a level, and I think that as it stands now, it's very loose, even weaker than that for the removal of the justice of the Superior Court. But this is the highest office of the judiciary, and therefore that guarantee or that protection of that office should be properly put in place, the necessary structures put in there to ensure that it's not taken advantage of by any government.
But we seem to lose sight of the fact that the first test of a case like this is to go to the Council of State, which is by law supposed to be an independent constitutional creation, which is supposed to be bipartisan by all standards under the provisions that sets it up. Should we not be satisfied that such a council can do a thorough job, and that if that council makes a recommendation, it is a truly bipartisan and unbiased council, and to the extent that it does so, we should trust that it is a neutral process?
Well, I mean, definitely the Council of States is a respected institution guaranteed and provided in the Constitution. But its independence has been questioned in a number of situations. Moreover, it doesn't, I wouldn't say it has all the competence to deal with judicial cases of this nature and magnitude. And in some jurisdictions, they have a judicial council or committee that is rather given such powers to ensure that members of such council or committee will be people of proven competence in the judiciary or in the with experience at the bar and so on, who can really make a determination that cannot be faulted. So, while I don't doubt the integrity of the Council of States, the fact that its independence has been questioned, and it seems to, even when they give a decision that the government, the president doesn't like, he's not bound by it and so on. There have been calls for the removal of the Council of State from the Constitution, and so I will not place much power or much weight on what the Council of State or what they did in the process, which therefore can say that it makes the process fair to the extent that one would expect from to determine the removal of the justice of the Chief Justice from her position.
That was Professor Kojo Appiaje Chia speaking to Umaru Sanda earlier following the removal of Chief Justice Gertrude Torkornoo there. Earlier, there were questions about whether or not the removal means that she's only been taken off the role as Chief Justice, whether or not she can return to the bench as a Justice of the Supreme Court. But I think the warrant I read earlier kind of explains it, does it not?
Yes, it makes the, so if you could read it again, yes. It makes the clear reference to her removal as Chief Justice and also a Justice of the Superior Court. Yeah.
So let me just go to the second line. I do hereby remove the said Chief Justice, Justice Gertrude Torkornoo from the office of Chief Justice and Justice of the Supreme Court with effect from the date hereof.
Yes. So there are those who belong to a different argument that will perhaps be in disagreement with Professor Chia's argument that she may return to her role as a Justice of the Superior Court. It takes you back to Article 146 that lays out the commencement of the process to remove a Justice of the Superior Court. The wording does not make a reference to removal of the Chief Justice per se, but it makes a reference to the removal of the Justice of the Superior Court. Okay. Yes, and so that's where some will have, in the interpretations that will be given, there will be a difficulty in saying that you're just removed. She's just being removed as CJ and may continue her role as a Justice of the Superior Court. Wow.
Will she then be entitled to the emoluments of Article 71 office holders?
I'll leave that for Sky to answer. Oh, but just as Sky has sat down, I think that I need to say, because earlier Richard Sky, my learned senior, talked about wearing black. Then that's the more reason I'm doing
You're also in black.
I'm not in black, not in solidarity or in. That's
but
not
your
to
legal
say
vacation.
So you are not solidarizing with
that's
that.
Not to say that I am pleased about her removal, but
Right.
I've been wearing black since yesterday because personally I'm bereaved. Yes, I lost my grandma, and that's why I'm in black. Yes.
Condolences.
My deepest condolences.
Mm.
But don't worry, you don't have to answer to anybody.
Well, Sky, you are mourning.
Yes, I'm mourning. I'm mourning
no,
because
mourning.
I feel that we have decapitated the head of the judiciary under unacceptable circumstances. I believe that the whole thing it's a mockery of justice in my respective view.
Because they said
and I say this without disrespecting the brilliance and the authority and the pedigree of people who sat on this particular
you have Justice Palman
and came out with a report. Their competence is not in doubt. They have their own weaknesses and strengths, but I believe that if you put everything around this particular case together, the trajectory of how it came to be and where it is today, I have very little doubt in my mind, if there is one at all, that this was not justice done, this was not due process, and I believe that in the fullness of time.
Sky, did they follow the constitutional requirement as laid down for the removal of a justice of the Supreme Court?
I have said here ad nauseum that in my respectful view, the constitutional provisions may have said that, do A, B, C, D.
Yeah.
But in my respectful view, that's not what they did. And I argue that, first of all, this whole process was bereft of any constitutional sanctity or authority, because we did not have a CI telling us what constitutes, for instance, stated misbehavior, that this is what should qualify as incompetence.
So I have, for example, key findings behind Chief Justice Torkornoo's removal. We have a news card out there, City ChannelOne TV.
No, I will come to that.
Yes.
There are three basic things that they said they found.
Yes.
The first one, okay, let me...
So, unlawful expenditure of public funds. The committee held that the Chief Justice caused the Judicial Service to pay travel expenses for her husband and daughter during private holiday trips in 2023, including per diem allowances. This, the report stated, was an avoidable and reckless dissipation of public funds. That's number one. Number two, abuse of discretionary power. The committee found that her handling of the transfer of one Mr. Bading breached Article 296A and B of the Constitution, describing the act as misbehavior. And then number three, interference in judicial appointments. The report also noted that she sought to bypass the established process for nominating justices of the Supreme Court, contrary to precedent set in the Ghana Bar Association case. The committee concluded this amounted to misbehavior.
You see, with the greatest respect, I think the committee has not yet done justice in this particular case. I think I say this with all the respect I can command, that they went to do their own thing, in my respectful view.
Is that the case?
The reason I'll explain why.
That's a serious point.
And the position I'm taking is consistent with something I had said before when Charlotte Osei was removed. I sat on, CCTV at the time, and I advanced a number of points as to why I thought that the process that was used at that time was equally defective. Now, you have listed the three main points that founded the removal of the Chief Justice of the Republic. Transfer of an officer of the Judicial Service. The Chief Justice was exercising, as we understand it, her administrative authority to effect a transfer for whatever reason. Now, we do know that if administrative decisions are made and a person aggrieved says that, look, I found problem with the decision that has been made by my boss or a person who has some control over me, there is a process for addressing that. If you look at the provisions of the Constitution, for instance, if there's a claim that my human rights has been affected by that transfer, the proper remedy will come under Article 33 of the Constitution. When you combine that with the national, the labor laws of our country, you can see proper remedy at the High Court, where you go and argue that, oh, your rights have been decimated by the Chief Justice of the Republic. You think that, under Article 33, your rights have been breached and all of that. It is for that court to make a determination whether or not, properly so-called, something wrong or right has been done. And that is, in my respectful view, is not a matter that a committee set up by the president should be looking into for purposes of removing a Chief Justice.
You think it's frivolous?
I think it is at best, it's unfortunate. It is unfortunate. And let me add to what I have said. You see, if you look at what did the committee say? The committee said that the Chief Justice breached Article 296 of the Constitution. Now, in my respectful view, we have two justices of the Supreme Court there, but they were not sitting as the Supreme Court of the Republic. We have a former Auditor General there.
Yes.
We have a military officer there.
Yes.
And we have a University of Ghana lecturer.
Yes.
But all of their wisdom put together will not rise to the wisdom of the Supreme Court of the Republic of Ghana. If you read the Constitution, Article 2 combined with Article 130 of the Constitution clothe the Supreme Court with the authority to determine what is a breach of the Constitution.
So it doesn't take the committee to determine that. It should be rather the Supreme Court.
It does not. So they,
you
by
have two
sitting...
justices of the Supreme Court, though.
Please, I'm making a technical legal argument.
I'm
that regardless of the wisdom they command, which I do not dispute, the pedigree they command, which I do not dispute, in my respectful and humble view, they do not amount to the highest constitutional court of the land as to make a determination of fact that there has been breach of the Constitution and therefore a person has got to be removed from office. Because when it comes to determining whether or not there has been a breach of the Constitution, it's a mandate squarely and solely reserved for the Supreme Court of the Republic. Now they, in the letters in circulation, we are told, determine that there has been a breach of the Constitution and therefore the Chief Justice be removed from office. In my respectful view, I think they exercise a jurisdiction they do not have or did not have.
So in this case, what's the remedy? It's the end of
the
story.
No, that's just the
it?
first leg of my argument.
Oh,
I make three main.
There are a number of them.
No, I make three main points.
Okay.
So in my respectful view,
yes,
if there's a question of breach of the Constitution, it was not for the committee to determine. It was a matter to be determined by the courts. Let the Supreme Court say that, oh, we think that on the facts, there has been a breach of the Constitution. And we'll see the consequences that flow from that. I make this point well aware that there have been consistent breaches over the years by all kinds of public officials. We've seen decisions of the Supreme Court say that the president violated the Constitution. In the case of Domelevo, for instance, Yao Domelevo, the former Auditor General, we're told President Nana Addo Dankwa Akufo-Addo violated the Constitution. Was he removed from office? In the case of Speaker Doa Jaho, we're told by the Supreme Court that he violated the Constitution where he decided that he was not going to swear the oath of office of president when he performed the functions of president of the Republic. So
there's evidence in the past that a breach of constitution has not necessarily led to the removal of an authority in a public office.
So the point I'm making is, beyond that point, it was not within the mandate of the committee to determine what is constitutional or otherwise.
Okay,
that's
so that's the first point.
Now, the second point that I make has to do with what do you call it?
The travel,
the travel,
the travel with the husband and daughter,
the travel
and
with
the
per
diem, and they say it amounts to there was an English they used. They said it's avoidable and reckless dissipation of public funds.
Yes. So again, when there has been what do you call it? An administrative expenditure.
Yes.
Which for some reason is found to be unreasonable or reckless or whatever, inappropriate. In my respectful view, the legal regime that deals with that is the Public PFMA, was it Public Financial
Management
Act. Under Section 7, it talks about who is a spending officer responsible for, expenditure and related matters, and whose job it is to ensure that expenses done in the name of the state by a covered entity follow due process of law, right?
Yeah.
And where there is failure to comply, the law provides specific remedies you can find under sections 96 and 97.
This is the PFMA.
Where you can surcharge in appropriate cases, and where there is a criminal element involved, you can also prosecute.
Okay.
Right. Now, the question you should ask yourself is, the committee goes and says that, we have found that, merely flying with your husband and your wife, your child, amounts to reckless expenditure. With the greatest respect, where within the ambit of this particular provision can we say that we can situate their finding?
Per diem allowances for the husband and daughter.
Exactly. Yeah. The point I'm making is that where it is determined, so it would have been the auditors who would have found that A, B, C, D was done, it was not done properly. So what do? They search the person that, you have not, you ought not have benefited. We see that all the time. Yeah. Public Accounts Committee is sitting now, right? People go before them and they are surcharged that, no, you go and do A, B, C, D, you have to pay back and all of that.
Maybe because this is the head of the judiciary, the standards are higher.
I am saying that, you see, they sat there respectfully as people who were seeking to enforce the provisions of our constitution. And I'm saying that when they talk about reckless expenditure, within what law? I have not seen the full report. We've just been told by what is in circulation that they made a recommendation to the effect that there was reckless expenditure. So within the ambit of the law, as we know it, that governs public expenses, where do we situate their finding? They determined that there was reckless expenditure, and I'm saying that even within the law, if you are found to have used resources in a way not toward, what you do is what? They cause you to refund in appropriate cases. If there is criminal intent established, then you can be prosecuted for specific things. On the facts, there is nothing like that.
So this is not enough grounds for the removal from office,
in my respectful view.
And then your last point, I'm sure, will be that of the interference in judicial appointments.
No, that's not. That's also an incidental
it's also
point.
One of them. Okay.
There was one other thing that they said.
Which is the third point?
Which said that yes, they said the president, the chief justice, wrote to the president then, and asked for certain people to be appointed. With the greatest respect. Again, it comes back to the point about whether there is a breach of the Constitution.
Let me just provide the information on that. It says the report also noted that she sought to bypass the established process for nominating justices of the Supreme Court, contrary to precedent set in the Ghana Bar Association case. The committee concluded this amounted to misbehavior.
Look, that comes within Article 144 of the Constitution, right? And I was in court on a matter having to do with such appointments. If you read the Ghana Bar consolidated case, which is Sky and some other people, I was in court about the procedure for appointments like that. And I took the view that the current arrangement doesn't serve the purpose that it was meant to serve. So let us create a regime consistent with the provisions of the Constitution that would ensure that we have a certain fairness, meritocracy and related matters in the process. Look, the Supreme Court came out with a decision. That decision, which I just referenced, does not say that where someone is supposed to be consulted and the person expresses an opinion, that should be grounds for removal.
Okay.
Hold on, please.
Yes.
I'm listening to you. The court basically told us that this is what you do if you want to appoint a person to the Supreme Court. Right? Follow this procedure. The president should do A, B, C, D. Nowhere in that decision is it stated that, if the Chief Justice of the Republic or maybe the Council of State writes a formal letter to the president to say that, oh, in our view, as part of the consultation process, we think that, oh, Caleb Kuda should be appointed a member of the Supreme Court. Then you go and file an action and say that, oh, because the Council of State made a recommendation, they have breached the Constitution. I find that, I mean, it's so unfortunate because, as we speak, who has determined that the Chief Justice has breached the Constitution? The committee, in their view. And as I've stated much earlier, regardless of all the wisdom they have, which I defer to, which I respect, they do not rise to the level of a properly constituted Supreme Court of the Republic to determine that, oh, on this matter, merely by recommending, writing to the President of the Republic, which is not even binding, per the decision of the Supreme Court in the Ghana Bar case and my case for that matter, which is not even binding. You are saying that, oh, they breached the Constitution and therefore the Chief Justice breached the Constitution and therefore let's remove her from office. I find that particularly troubling.
So, concern I have is when I listen to the procedure established in the Constitution for the removal of the Chief Justice, it's not as rigorous as that of, say, the President or the Speaker of Parliament. So you need to test majority in Parliament in order to start an impeachment process against the President. Same for the Speaker. Now here you have the
Speaker is much.
Speaker as well.
Quarters, I think.
A quarter, fine.
Three quarters.
Yeah, okay. But in the case of the leader of the Judiciary, then you write a petition to the President. It is forwarded to the Council of State. They determine a prima facie against you, send it back to the President. The President sets up a committee to probe the matter, and if they establish that the prima facie case is grounds enough for you to be sacked, then the President, as it were, appends approves the recommendation, and that is it. That's it for the removal of the CJ.
Yeah, because
that's it.
Look, I don't think that
Did I get that right?
Yes. So the President, in my respectful view, and this is consistent with the point I've made in the past, the President hasn't done anything wrong by saying, "Oh, I've removed you," because the Constitution says that if the committee says that remove the person, you remove the person. So they go to the President and say that, "Oh, we have said remove the person." What would the President do? The President will simply remove the person. But you see, my argument is based on putting everything together. Putting everything together, I am not persuaded
that there has been justice done for the removal,
or that there has been due process. And I must say this because I know some people are running around saying that, oh, this guy something about, shall I just say in the past. Look, if you go and listen to that video, the very points that I'm making today, I'm basically restating those points. In the case of Charlotte Osei was removed because we were told that, oh, they said she had breached the procurement. I stated publicly
there's still
that, look,
remedy.
I mean, if there is, the remedy provided by the law. It's not that you remove the person, because in any case, at the level of criminal liability, it is not about whether we think that, oh, you have breached and therefore we should remove. No.
Sky, let me just ask you this question. You see, what beats my mind then is that
I said in that particular case that it was a matter for the court to determine.
Fantastic.
And that if you want to prosecute, go and prosecute. If there is a finding of guilt, then you can use that as basis to say that there has been stated misconduct.
So this morning, your argument, which you've made very forcefully, is that all the points we have come to know which forms grounds for the removal of Chief Justice, it's not convincing for you, it's not substantial. In any case, there are remedies that could have been used to address them. Fine. Now, we have seen situations in the past where there have been attempts to petition, or there have been petitions to have justices of the Supreme Court removed, and we've had the judiciary, as it were, support their own, such that such petitions have not traveled their full course for us to get to where we are today. We've had two senior justices of the Supreme Court on this committee. And I get the point you make that, okay, fine, their expertise, their wisdom notwithstanding, it couldn't come to a set and established panel of the Supreme Court, blah, 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 blah. But what is it so wrong that the judiciary justices won't stand by their own? I'm struggling to get it.
Well, I cannot be a soothsayer to go into the minds of the justices and the members of the judicial whatever to determine why they may or may not have spoken clearly. But you see, the majority, even if the thinking is that the majority has taken a decision and therefore we should go with it, it's not always right. The people of Ghana did not vote for President John Mahama to come back and sort of create situations like that, in my respectful view, undermine the rule of law. Because I take the view strongly that, look, if you want to remove a Chief Justice from office, when we see what amounts to stated misbehavior, we should know it.
It must be obvious to all.
We should smell it. Let's say, for instance, the Supreme Court, under our rules, has the capacity to be constituted by one judge. Let's say, for instance, the Chief Justice of the Republic is presiding over matter having to do with divorce, and some consequential orders or some interim orders have to be made. In this case, the Chief Justice constitutes herself into a judge to preside over that matter and give specific orders regarding a matter currently pending before the court. And maybe the Chief Justice has something to do with one of the parties, maybe the people fighting to go on to have their divorce, and then maybe they have an amorous relationship.
As is the justice and
exactly, they have been seeing each other, doing all kinds of things.
That one is more obvious.
You see, that is. And that is like you can smell it when you come close to it.
I get your point. I have a message for you though.
Hold on. But where they say, somebody has moved somebody from this place to the other place, and therefore we should remove. It is an administrative matter.
We're running out of time. We have some interviews to run. Good morning, Caleb and team. In my respected view, I believe Richard Sky is wrong. His assertion that the former CJ has been hounded out of office wrongly is not just laughable but very dangerous. Nobody's above the law, even the CJ, even the president. And an elected official is liable to being impeached. His interpretation of the law is flawed in many respects and totally unacceptable. Eddie Kweno EB
what has he said
from
that responds to the substantial issues?
So
and just quickly
please.
For me, I'm not going to have a position as to this subject, but for me, ordinarily, the investigation and subsequent removal of somebody of such a high office as the CJ would have signaled that indeed there's rule of law in this country, and it would have shown transparency and accountability. The exception is that in this country everything is riddled with politics. So it becomes difficult to know whether indeed there's due process, there's all,
because you can even pursue due process and still achieve your political ends,
or whether there's a political interest at
when
hand.
you know it. Look, a typical example, Daniel Domelevo.
Sky, we are wrapping up. we are out of time.
It's a fine manner.
We'll take a break here.